If you're just joining us, we're getting ready to talk about Bard, Why the Innocent Can't Get Out of Prison. Terrific new book by Professor Daniel Medwed. And he's with us here this evening to talk about this really very important book. And so I think what we're going to go ahead and do is jump in and get started. I'm Pam Metzger. I'm the director of the Deason Criminal Justice Reform Center at the SMU Dedman School of Law in Dallas, Texas. And I am so thrilled to be joined tonight by Daniel Medwed. He is a professor of law at the Northeastern University School of Law. He is a longtime both lawyer and advocate, thinking about innocence and all the challenges to both proving it and then making it meaningful in the courts, which is not necessarily the same thing. And he and I are alumni of the same illustrious organization, the Legal Aid Society of New York, which was far more robust back in our day before the union busting started. But I wanted to welcome him here, and I wanted to begin by just framing this book for folks. A book just came out in September, so I think it's possible that some folks may not have had a chance to read it or finish reading it. But the book itself is, kind of part tutorial, part personal narrative. We get a look at, what the experience is of being a lawyer for people who claim to be innocent but have been convicted by the system. And at the same time, it offers a primer for non-lawyers on how to understand the obstacles. What are these hurdles, and frankly, almost unsurmountable hurdles to achieving justice for the innocent. And it's filled with stories. And as I was reading it, one question that immediately came to my mind, Daniel, is there that one case? I mean, we all have one, maybe sometimes two or three. Is there one case in particular that kept you up at night and made you say, I have to write this book?
That's an amazing question. So first of all, before I answer that, just thank you, Pam and Kenitra and everyone at the Deason Criminal Justice Reform Center for inviting me. I've been a huge fan of your center and of SMU Law School, and it really is an honor to be here. In terms of your question, Pam, there is one case. If I could describe it, it would be really helpful, I think. So on February 3rd, 1999, at about 8:20 p.m., a large white man went into a restaurant. There were only two people there, a cook and a waitress. And while the cook was preparing the man's dinner, he robbed the waitress at knife point. He took $32 and he fled. He fled in a late model white car with a T and a 1 in the license plate. Okay. And then basically, they described the perpetrator, both the cook and the waitress described the perpetrator as a tall, heavyset white man in his mid-30s. Police came with a six-pack. We know these six-packs, right, Pam? This was out in Suffolk County, Long Island. And the photo contained a picture of a local ne'er-do-well named Stephen Schultz, who had a pretty lengthy criminal record, was 6'2", 250 pounds, mid-30s. So they both identified Stephen as the perpetrator. He was too poor to pay for a lawyer, so he got a lawyer assigned to him. The lawyer didn't do anything. And while Stephen is in lockup in Suffolk County, he reads the local newspaper. He claims to be innocent. He turns down a plea deal. He's reading the local newspaper, and get this, he comes across the following article, and I'm paraphrasing here for, dramatic effect. Large white man pleads guilty to 6 robberies. Another man who looked just like Stephen had pled guilty to 6 storefront robberies in the vicinity of this town in Long Island, bookending this particular crime. So the crime happened on February 3rd, 1999. These other crimes happened between January and March. Stephen called up his lawyer, and as a very distinguished trial lawyer, Pam, you're going to be horrified by this. Stephen called up actually his sister, who called up the lawyer and said, you better start investigating this. Come on, Barry was the name of the guy. And Barry said, I'm too busy right now. Let's see how this plays out at trial. So he never bothered to investigate this third-party perpetrator, this other guy named Anthony Guilfoyle. So case goes to trial. And at trial, some amazing things happen. First, the cook gets up there and basically corroborates the photo identification of this guy, Stephen. That's the guy I saw in the restaurant. He ordered a dinner. While I was cooking it, he fled in a white late model car with a T and a 1. Then the waitress gets up on the stand. And in the movies, we've seen this, right? Usually what happens is like the victim of the crime will start crying and sort of slowly point a wobbly finger at the defendant, or maybe like boldly brand him as the perpetrator. But something happened here that I've never seen. And Pam, I don't know if you've seen this. She looks at the guy in the eyes, the defendant, Stephen Schultz, who became my client, and she says, now that I see him in the flesh, that's not the guy. The guy who did it was taller and heavier. Lo and behold, this other man from the newspaper was taller and heavier than Stephen Schultz. So because the lawyer had never investigated, he didn't really know what to do. He tried to get this other photograph into evidence because of the rules of evidence in New York, he was stymied. Long story short, Stephen Schultz was convicted, sentenced to 11 years in prison, having turned down a plea bargain of 3, and later wrote me when I was running a small innocence project at Brooklyn Law School to say, hey, will you help me? So the book really describes this case and the sort of twists and turns as we tried for many, many years to get Stephen out, even after we compiled all of this evidence pointing to this other suspect, Anthony Guilfoyle.
So, I'm sure that the audience is wondering what happened.
Yeah.
You want to tell the audience real quickly how that story ends? I know because I got to read the book.
You know, because you read the book, right? So this is a quiz about whether you got to the end, right, Pam? I know you did because everything you start, you finish. I know, Professor Metzger. So yeah, here's what happened. My students at Brooklyn Law School, and for students who are participating, this is just a real shout out to students everywhere who are involved in clinics, who are involved in things like the Deason Center, who are active, experiential learners, because you really make a difference in these cases. So my students and I began to investigate this case, and here's what we found. First, we showed a photograph of this other suspect, Anthony Guilfoyle, to the waitress, and guess what? She identified him with 90% certainty as the man who had robbed her that day. We also then visited the roommate of Stephen Schultz, his alibi witness, who had not been called at trial because the defense attorney didn't think he was credible. We got an affidavit from the alibi witness saying, we were home together watching television that night. We were watching an ABC sitcom called Dharma and Greg. I don't know if anyone remembers that show. Now, for those of you who remember this show, would you ever admit to watching it unless it were true? Like, it was not a good enough show for you to lie about having watched it, okay? So that made me think this was really a credible alibi, because why would you admit to watching this really bad show? I'm only partially kidding. And then one of my amazing students, at 2L, she started doing a deep dive into New York State motor vehicle records. And guess what she found? She couldn't find any car that had been registered to this other man, Anthony Guilfoyle, the guy we thought had done it. But instead, she found a car registered to Anthony Guilfoyle's wife, Kim. And guess what? It was a white, late model Oldsmobile with a T and a 1 in the license plate. We knew we couldn't present this newly discovered evidence to the appellate court because of the rules of appellate procedure. You are limited, of course, to the record below, to issues that were presented at trial, and especially in New York State, issues that were adequately preserved at trial, where there was an objection or an offer of proof. So we knew we weren't going to win on the direct appeal. So we pursued a New York State post-conviction remedy, very similar to the ones that they have in Texas, where you can present newly discovered evidence that casts doubt on the conviction. If I recall, Pam, correct me if I'm wrong, in Texas, that evidence has to unquestionably point to innocence, or there's some really high standard. I don't know if that's necessarily the case. But in New York, it's much more.
It's higher. The answer is it's high everywhere, but yes, places like Texas tend to make it very high.
Very high.
Not unlike the federal system.
That's right. And you are a federal defender, so you know all too well about the federal system and how horrible it can be on this. Well, in New York, the test on paper is pretty generous. You just have to show newly discovered evidence that you found that had it been presented at trial, the result would probably have differed. This remedy, which is codified in New York and in many states, has its origins in an ancient British writ called the Writ of Error Coram Nobis. And I devote a chapter to this. Coram Nobis means before us. And it says when you have newly discovered evidence, you can go back to the trial judge and try to convince that judge that your guy deserves a new trial based on this new evidence. So one of my students and I drove out to the courtroom just to convince the trial judge, a judge named John Coppertino, a very salty law and order ex-prosecutor, that we needed to get a hearing, just a hearing on this evidence, not actually get a new trial yet, just give us a hearing, let our evidence go through their paces. And I'll never forget, I really wanted to put on a show for my students, because Pam, we can all relate to this. We want to impress our students. We don't want them to really see, the flaws in our performance. So, here I am teaching them how to be a lawyer, and they actually haven't seen me practice. So this is one of my first moments actually being a lawyer. So I felt extra pressure, not just to get a hearing from my innocent client, but to impress Roger was the name of my student. And I get up there and the judge won't have any of it. He looks at me and he says, "This is ridiculous. This evidence wouldn't have made a difference. I remember that trial. I think that the victim didn't identify your client because she was scared, not because she thought it was someone else. I'm not going to even grant you a hearing." One of the delights of being on this book tour is I get to meet wonderful people like Pam. We've had a chance to reconnect. And I gave this talk and talked a little bit about this case recently. And a woman came up to me, a very old woman with a cane, and just a wonderful woman. She said, "I used to live in Suffolk County in this courthouse, and I was a real estate agent. And I remember interacting with those judges. And that Judge Coppertino, guess what his nickname was?" I said, "I don't know, but this has got to be good." She said, "Crappertino. You can call him Crappertino." So I probably shouldn't, but I'll take my chances. He denied our motion without granting a hearing. He didn't give us a new trial, didn't even give us a chance to present our witnesses. We lost on appeal. We lost in the highest court in New York. And it took 8 years before he was freed, not on the grounds of innocence, but on, and Pam, you would have been able to predict this because it relates to your area of expertise, he was released on the grounds of ineffective assistance of counsel on a federal habeas action based on the idea that this lawyer, Barry, should have done a better job of investigating the case, vetting the alibi witness, investigating this third-party suspect. So I think, and that's a relatively long story, I'm sorry about that, Pam. I think that's the story that really stuck in my craw and motivated me to write this book. How can you find all this evidence of innocence? And it takes 8 years for you to clear the person. And even then, the person is not cleared and declared innocent, but is just released, quote unquote, due to a constitutional violation.
So, listening to you, first of all, this resonates for me so much. I have a client who, former client now, and a friend who, was convicted in very similar circumstances with a 10-2 jury.
In Louisiana.
At that point allowed in Louisiana on a single witness cross-racial ID. And, the twists and turns you're describing, right? The repeated appeals, the efforts to make a collateral attack, the federal habeas process. It all smacks of one thing, and you say it in your book very early on. If you got to choose between procedure, which is the way a case gets through the courts and what the rules and obstacles are, the procedure is kind of the traffic cop of evidence and of proof, right? Or substance, which is really, kind of the who did it and what's your proof and how do you get there. I'll take procedure anytime. I think that's right. I think that is the argument that's very clearly not just illustrated in your book, but I think it is the reality of how we practice. And, I read a book like this and one of my reactions is, oh God, no wonder my students look at me and they're so depressed sometimes, right?
Yeah.
Because the reality is that what you're describing for Mr. Schultz, or what any of us have seen in any number of cases, is that proof of innocence seems to have precious little to do with what happens to innocent people.
You're right.
And, folks in Texas may be watching Rodney Reed's case very closely.
Yes.
There's been a lot of conversation around a number of these kinds of cases in the country. Let's talk for a second about what it is to be in an adversarial system where procedure becomes the roadblock. And I want to, for the law students, particularly who are here, but we had other folks as well, I want to put this in some context. You have an adversarial system where, in theory, you have kind of equal champions. Put a pin in the question of whether they're equal, but they have kind of this clash. These are my knights, going towards each other with their lances. And you're going to get some kind of truth out of this. But even if that process were completely fair and on a level playing field, the beyond a reasonable doubt standard, which gives the benefit to the defendant, very quickly evaporates, right? And from there on out, the hurdles just get harder and harder and harder for anyone wanting to challenge a conviction. Right? So let me ask you, what are the primary justifications that people give for how hard it is to undo a conviction? And then what are the biggest arguments for why that's wrong?
That's a really important question. So let me try my best at that. So I think, Pam, there are two major arguments in favor. The first relates to the idea of the trial as the main event. Actually, in a 2017 Supreme Court case, Davis versus Davia, the Supreme Court even said that. The trial is the main event. It's mentioned twice in the Constitution. There is no reference to the right of appeal at all. So the idea, not to use, well, I am using a boxing analogy. I don't like to use sports analogies, but the idea is the trial is the main event and the appeal is the undercard. It's less significant. So the idea is what happens at trial deserves deference. It deserves respect. That's where facts are vetted. That's where I really liked your analogy or your descriptor there, Pam. That's where the lances come out and the battle is fought. Afterwards, when we're taking a look at this sort of through the lens of hindsight, we should defer to what judges did, defer to what prosecutors did, defer to what defense lawyers did, defer to the jury decision. So I think that's one rationale, which is the trial is war. That's where the presumption of innocence holds. After that, the presumption switches. It's a presumption of guilt, and that would justify having a series of obstacles. I think the second major justification relates to the concept of finality, a very practical concept, which is that at some point, criminal cases have to be over. You've lost a trial, you've had your right to appeal, maybe there are one or two post-conviction collateral remedies that you can attack a conviction from on the side, but we're going to make it really hard to do that. The undercard isn't as important as the main event, and at some point these cases have to be final. There has to be an end, or else victims won't have closure. They'll never be able to sort of put this case to rest and think that it will never, be resuscitated and cause them angst again. And prosecutors and defense lawyers need some finality too, to simply march on to the number of other cases on their endless list. And so sadly, I think this idea of the trial as paramount and finality as an important litigation value takes precedence over the whole idea of accuracy. This might be okay, and I'm curious what you think, Pam, if in fact the trial was a good mechanism for reaching a correct result.
Right.
So everything about this presupposes that the trial works, and therefore you should reverse the presumption of innocence, make it a presumption of guilt, and make it really hard to overcome it. Right. But if the trial doesn't work, and by now we know that it doesn't work, then this whole concept doesn't really carry water.
So I guess I'll try and answer your question. And I got a couple of different answers. One is, nobody has a trial anymore. I mean, I think the 95%, the stat that people give of 95% of all cases end in a plea, I think is generous.
Interesting.
My guess is, depending on where you are, probably a much lower percentage of cases go to trial.
I think you're right.
And that data is pulled, I think, from the 75 largest urban counties. So it's not necessarily a reflection of what happens in most places in the United States. So one is people don't have trials, and we can talk in a second about the dangers of plea bargaining and some of the law that allows these enormous trial penalties and threats that put people into jeopardy if they choose a trial. But the other piece, of course, is that trials aren't always perfect. In fact, they're often quite bad. And, so we can talk about, problems with evidence that's being withheld or evidence that police don't ever find. It's not always malicious. There are plenty of cases where it's sloppy police work, plenty of cases where there are miscommunications. We can talk a lot about ineffective assistance of counsel and how it is that failure to provide early high quality representation can doom a case. But even if that were true, I mean, even if you had a great trial, the reality is that innocent people still get convicted. I'm thinking here about Larry Youngblood for a minute, right? So for the, Youngblood is a case where there's a man charged with a horrible sexual assault of a young boy. He is, as I recall, a one-eyed Black man with a limp.
Yes. Well, yeah. He had a discolored eye, some very
Some,
unusual appearance.
and that they get a fairly good lineup.
Yep.
Child picks him out of the lineup. It seems, again, the lineup is a fairly strong one. You have to find 6 people who fit that description. He had a pretty vigorous defense. The reality is that even with a good, strong, vigorous defense, he was convicted.
Yeah.
The lawyers held on to the evidence. Many years later, the technology becomes available to test the evidence using DNA, which is a really powerful tool, but only available in a limited number of cases.
Yes.
They test it, and it turns out that Larry Youngblood was not, in fact, the person who was guilty. Someone else was, and they were in custody. And by most accounts, Larry Youngblood had a fair trial with the wrong result. So having laid those 3 problems out, can we take them in reverse? What do you say about the fact that you can have a really good trial and still convict innocent people?
Well, that's the scariest thing, right? I think that is the scariest thing. And in many respects, that's what augurs in favor of having a much more robust appellate and post-conviction process, because I love that you brought up the Youngblood case, because he did have good representation, but largely because of where we were in terms of technology, the biological evidence couldn't be tested for DNA back in the 1980s. And then there were problems. It was lost and it wasn't housed properly. So there were some mistakes that the government made, but really the defense did a good job. And prosecutors largely played it fair. It was just by the standards of the day, the technology wasn't necessarily treated properly. Not that there was evidence of bad faith, it just wasn't treated as well as it could have been, right? So I think that's one reason why we have to have mechanisms, more robust and transparent mechanisms for looking at these cases, because even in the best case scenario, mistakes will occur. I mean, it's often said, right, that anything devised by humans is going to be fallible because we're fallible. We make mistakes. This is not a question of a machine where you add the facts to the law and voila, there's proof beyond a reasonable doubt. There's human error at every stage. And it could be implicit bias. It could just be structural or technological glitches. Who knows? With respect to some of those other errors, I think you're absolutely right. You alluded to some of them before. Brady violations where prosecutors don't turn over the evidence. You mentioned the lack of a level playing field at the trial of Sphere. That is absolutely a major problem in these cases. So if I were to write another book, I don't know if I have the energy or the ability to do anything else. I think I would focus on some of those pre-trial, investigative, and trial procedures that make it so hard for truth to prevail at trial.
So let's talk about that piece about pretrial procedure for a minute,
yes.
because volume-wise, it's really, really hard to get an innocence case through the system. And so,
yes.
If it's hard for a rich man to get into the kingdom of heaven, it's probably harder for an innocent person to get into the courts.
Right.
And what strikes me frequently when I think about these cases is how much can go wrong very early on. So I'm thinking now of a case in New Orleans that involved a murder in the Bunny Friend Park, where defendant was arrested, accused of the murder. Family happened to have enough money to hire a lawyer named Kevin Boucher. Kevin was privately retained, was able to either himself or with an investigator get to the site of the alibi, which was actually, I think, in a shopping mall in another state, and produce either video footage or receipts that demonstrably showed this person was innocent. But in many places around the country, there's no meaningful right to counsel at those early stages. You don't have a lawyer early on. And people may or may not know this, but most security footage in convenience stores and gas stations and banks is routinely erased and re-recorded on a pretty regular basis, sometimes with as little kind of lag time as 48 hours. That strikes me when I think about this problem as perhaps the earliest intervention point for the criminal system, at least for the criminal legal system. Maybe policing has a different moment, but if we think about the criminal system as a funnel, right? There are all these people who are arrested, and then prosecutors maybe or maybe not get involved early on. But the minute a lawyer gets involved, there's an opportunity to push a case up and out of the system again.
Yes.
Is the first appearance in court the right moment? Is it something in policing that's the right moment? What's the earliest opportunity to tackle the innocence problem and prevent it?
I'm just going to throw this out there, and I might be off base. I often am, Pam, but I'm curious what you think. What about just having lawyers on call whenever there's a crime? They can go down to the crime scene and be there when the crime scene investigators are scouring for evidence. And then later they'll be involved whenever somebody becomes a suspect. But the idea is that there's a defense lawyer involved in the case, the potential case, and not just assigned to a person. I don't know. I mean, I'm just throwing that out there. I mean, that's early intervention,
yes, it
obviously.
Is.
Pre-arrest, pre-investigation, lineup, everything. But I think you're absolutely right, because without that early intervention, things can snowball pretty quickly. And as you well know, the prosecution holds all the cards. They're not required to even disclose evidence that's favorable and material to the defendant, so-called Brady material, until the eve of trial, which means that you can plead guilty in most jurisdictions without having even seen the evidence in the prosecution or the police possession that suggests you might be innocent. So, I mean, I often do this with my students. I'm curious what you think about this. I'll say to them at the beginning of the term, I'll say, if I were to offer you a B right now, in exchange for not doing any work in this course, not writing a paper or taking the exam, would you take the deal? Now, a couple of them are like, ha, 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 I'd take the deal. And I'd say, but wait, you're forsaking the A of acquittal. You're forsaking going to trial and doing your homework and confronting your witnesses and getting that A. But then a lot of them will say, well, we don't know what your grade distribution is, right? We don't know how often you fail people or you give people C's. So I'd rather have a bird in the hand, a B, when I could be risking a C or a D or an F, and I don't even know what the chances are of getting an A. To some extent, isn't that what the plea bargaining process is like for someone without any sense of the evidence against them, the evidence against, under this kind of pretty poor analogy, the absence of grade distribution information, right? Like, I mean, I'm just curious. I would take the B, I think, a lot of times if I were worried that I'd get an F.
I do think it's an overly generous analogy. It's an interesting one, but what I would say is it's more like, if you take the B today,
yes,
great. But if you don't get 100 on the final exam, I'm going to fail you.
That's it.
And that's what we talk about as the trial penalty.
Yes.
This idea that, so again, for the law students who are listening, the Supreme Court long ago said in a case called Borden-Kirscher versus Hayes, that it's perfectly fine to ramp up the penalty that someone is facing if they refuse a plea bargain, and not by adding a couple of months or a couple of years. But I think in Borden-Kirscher, it went from a max of 2 or 5. It was a single digit max. Up to I think a 25-year max.
It was a huge multiple. That's right.
And the Supreme Court's like, that's fine with us. And in fact, as recently as, I don't remember the date of the Ruiz case, but very recently, the United States Supreme Court said, not a problem if people don't get to look at evidence or know what's exculpatory. Because plea bargains are really important. It's how the government gets its work done, and we should be very reluctant to interfere with the plea bargain train. I think you are 100% right. I want to double back to this really intriguing idea, though, about a lawyer at the scene. I thought,
I'm curious because I know you've done a lot of interesting work. You're doing some research on this, and isn't the center heavily involved in advocating for early pretrial intervention for lawyers, right? So I am curious what you think about it. Is it pie in the sky?
Well, I mean, the answer is
yes.
Yes, and so what? I mean, that's the beauty. That's the beauty of being a law professor and a researcher. The hell with whether it's realistic.
Exactly.
I think what's fascinating about it is I thought you were going to go for an Escobedo approach, which is counsel at the station house, a lawyer the second you're arrested.
Station house. Yep.
What you're suggesting is something I think that makes me wonder about civil legal systems. So civil legal systems are ones in which the lawyers and the court cooperate in a sense to investigate. And so in a civil legal system, it might make a lot of sense to have the defense lawyer on the scene because the parties are viewed as cooperatively being involved in some ways in a search for the truth. What I wonder is whether lawyers on the scene, setting aside for a minute the resourcing question, whether they ultimately maintain their adversarial skepticism. Right. And I would also wonder whether the role specificity that we have for lawyers transcends some of that. So what I mean here is we have a tendency, there's a lot of literature about what are called courtroom working groups, the idea that people who work together form relationships, they adapt to each other's working style, they often if you're in a courtroom, for example, they might trade off. Judge will say you can win this one, but now you're going to lose this motion.
Right.
They may compromise because the defense lawyer knows the prosecutor has a soccer game for their kid to go to. There are all kinds of personal relationships. So if you had just one person, I would worry about forming a work group with police. If you have multiple, I'm not convinced that everyone belongs on a scene. And of course, we're back to talking here about high stakes cases. The bread and butter of the criminal legal system is misdemeanors, and followed by low level offenses where there isn't going to be anyone at the scene. These are complaints that are called in, or the quote unquote evidence is someone who's in a place where they're not supposed to be and they're trespassing, or the evidence is the police officer says, here's the baggie of marijuana I found. So I don't know, except in the law and order crimes. Yes. I can see where it would be very helpful
serious
to have
felonies,
a crime scene ombudsman type person.
Yeah.
But I also worry about them becoming a witness.
Yes, that's a good point.
Witnessifying. I'm more inclined to think that a big piece of this is what I'm going to describe as lawyers with skepticism early and often. So I will tell you a story and see what you think. Back in 2015, when New Orleans had a wait list for lawyers, the public defender withdrew from cases where they were overburdened. And in one section of court, a judge assigned me to the cases of 7 people, all of whom were charged with offenses that carried penalties of life in prison without parole. So they'd been arrested. They'd been arrested. They'd been through the prosecutorial review process. They were indicted. They were all looking at life in prison without parole, or what we call LWOPs. And my job was to set up some systemic litigation. So I did not represent all of them. But ultimately, what we learned was that none of them were guilty of anything near the magnitude of what had been alleged. One was acquitted in half an hour after waiting for 4 or 5 years for a trial. 2 pled to misdemeanors. 1 pled to a 6-month misdemeanor after serving a lot of time longer than that. 1 was demonstrably innocent. All you had to do was watch the crime scene video, which neither the prosecutor nor the defense lawyer assigned at the beginning had done. And so there's a piece of me that believes that it's the length of time people wait in custody, although this is also true for people who are out on bail. But that there's this coercive piece of people of uncertainty and incarceration where people will do anything to have certainty and do anything to walk out the door.
Exactly.
We used to say in my office to people, and we were only half kidding, this is such a good deal, even an innocent person should take it.
Yeah. Wow. I didn't realize, it was articulated that way.
That was what we would say, because, if you're looking at 10 to life, and someone offers you 36 months, that's your B instead of an F, I think.
I think you're right. And I mean, it depends. We all have different levels of risk tolerance, right? So some people are looking at the life sentence and they're just not going to take that risk. They will take the deal to avoid that risk. Others believe that they should take the risk, either because they overestimate their odds, or they underestimate the prosecution's ability, or they're risk takers, or they want to stick to their guns and claim to be innocent. So going back to my Stephen Schultz case, he, as I said, got 11 years after being convicted at trial. His deal offer was 3 years in prison. Mm-hmm. Now, for a guy with a lengthy rap sheet like he had, 3 years was a pretty good deal for a first degree robbery case. But he insisted, I'm innocent. He thought the system would work. He then gets socked with 11. And he writes me, as I said, asking us to take the case. And on my first conversation with him, one of the initial things he said to me was, I wish I'd taken that deal. Right.
Yeah, I underlined that in your book. All right. That line, because that's every trial lawyer's nightmare.
Isn't it? It's every trial lawyer's nightmare, right? Like and I mean, I think it's an amazing phenomenon, because there has to be some differential, of course, between what you're facing at trial and the offer, or else there'd be no incentive for you to take it, and no incentive really for prosecutors to offer it. But I think the gap is too wide. So I'd love your take on this, and I float this in the book as well, and I'm sure you have some views on this, which is, and I bet you have some strong views on this, what about just limiting that differential? So Stephen couldn't be offered 3 years when he's facing 11 because that 8-year trial tax, as people call it, or what prosecutors say, it's a plea discount. It's an early bird special. You get an 8-year deal by pleading out early. Eating dinner at 4:30 is cheaper than if you go to dinner at a civilized hour. But what if you just minimized it? And so you could only offer Stephen, say, 8 when he's facing 11. There's still a gap. So if Stephen's guilty, he takes the deal, but it's not such a gap that it would be coercive and lead an innocent person to do it. Italy does this. The Italian plea system says you can only give a 1/3 discount. So if you're facing 9 years in prison, you can't be offered less than 6, and only certain types of crimes are even eligible for pleas. What are your thoughts on that? I'm just curious because I know there's some negative effects for many defendants, to say the least. It's ouch,
is my
right?
reaction.
Because it's a mandatory minimum, basically.
Well, yeah, let me say a couple of things. One, I think the idea of capping trial penalties only works in a determinate sentencing structure.
Yes,
so for students,
you're
that's
right.
where there is either a sentencing guideline structure or clear mandatory minimums. But if you live in a world where every crime carries, just hypothetically speaking, anywhere from 0 jail time to life in prison, then what is the discount? So I would suggest that to work a system like that is a discount from the prosecutor's original plea offer, which is a suggestion I've heard. In fact, recently someone just suggested this. I wish I could give credit, but my brain is frozen. But I think trying to get people to, let me back up. Ever since Lafleur and Fry, which were the cases in which the Supreme Court said that the plea bargain process itself is one in which you have the right to effective assistance of counsel. Prosecutors have been under enormous institutional pressure. This goes back to finality, to document that defendants have received the plea offer that was made. That's because the Supreme Court reversed a very unusual decision, a conviction on a habeas petition that complicated post-conviction litigation because a defendant had not heard that the plea bargain had not been communicated to him. There's more, but that's enough for this purpose. So prosecutors do now tend to document either on the record or in writing what the plea offer is. I think perhaps a better version of the rule is to say that you can only have, a 10% or 15% increase over the plea. There are a couple of problems I think with that. The one is that I was never an appellate lawyer. I've done some habeas work, and I've done a few appeals, but most of my work was in the trial courts. So I represented an awful lot of guilty people.
Of course.
And something, there's a bad thing that happens at trial, which is all kinds of other stuff tends to come out.
Right.
And sometimes, even if you're not guilty of the thing you're charged with, you might be guilty of something else. Bad things come out, and you can't control what judges do. I don't know whether you can confine judges to the scope of the bargain that prosecutors offered. That seems to eliminate a piece of judging. The other thing I'll say is, having lived through the federal sentencing guidelines in a variety of, procedural moments for the federal government, what I've learned is that you can subvert any system. So there's nothing really in a elimination of the trial penalty world that would stop prosecutors, for example, from making an offer that's much higher than what they really think the person deserves.
Yeah.
And then if the person pleads guilty, turning around and saying, actually, I want to give you less.
Mm-hmm.
In other words, I worry that it's very easy to game these systems.
Right. Yeah.
I guess I'm deeply skeptical as well about any of these kind of procedural adjustments, because while I agree with you that procedure is king, procedure trumps substance any day of the week, I think of the criminal legal system as kind of, it's a little bit like hydraulics. If you think about a sprinkler, if you plug up one piece of the sprinkler, all the other parts of the sprinkler just go faster and harder. I think that's what we saw with mandatory minimums. I think that's what we saw with the federal sentencing guidelines. I have this feeling that might be what would happen here. Maybe I'm wrong. I think it would be an improvement. I just worry that people will find ways to game that. We all do. It's part of the process of handling large volumes of cases.
And probably the charging is one place where people would game it, right? So if a prosecutor realizes this case really isn't worth 8 years as a plea, I'll just charge it lower so that I can offer the person a better deal and be done with it. So that's one advantage, I think, from the defense perspective. But I'm not sure that that'll happen. I agree with you. I mean, what I'm trying to get at, and I don't know if it's legitimate or not, well, I think it's legitimate, but I'm not sure exactly how to go about it, is to encourage cases that are close calls, where there is a viable defense, where there is colorable innocence or possible innocence, to let those cases go to trial. Because then even if you lose at trial for all the reasons we've already articulated, at least there's a record on appeal that you could attack and possibly engage in collateral litigation. Again, that's not a panacea to all this, but that's better than these plea bargain cases, this sort of unknown quantum of innocent people who've pled guilty. The National Registry of Exonerations, when I was doing research for this book, I found that they had documented 549 cases where people had pled guilty and then were later exonerated on grounds consistent with innocence. That has got to be the tip of the iceberg. Because I know when I was running this Innocence Project at Brooklyn Law School for 4 years, as a matter of frontline criteria, eligibility for us to take on a case, you had to go to trial. We just did not have the bandwidth to deal with plea cases and to deal with something on the record where the defendant was admitting under oath that they committed this crime. We just thought that that was a burden too heavy for us to carry. It's hard enough to win in a case where the person's claimed innocence throughout. But the question then is how to get there, right? How to encourage more trials and trials in the close cases, the ones more likely than not to involve a potentially innocent person.
So I want to pin you down on this question of innocence.
Yes, please. Pin away. Ouch.
Ouch. Abby Smith, once, and I think she's written about this since, but Abby Smith, who's also written a book about some of these issues, professor at Georgetown, talks about, wanting to run a guilty project.
Yes.
Guilt project, not an innocence project. And I get this, right? Innocence is a very sellable narrative, but I think we have to, I want to ask what you mean by innocence and cases that should go to trial.
Yeah.
Because I think there's factual innocence. I didn't do it. I wasn't there. I was nowhere near. There's legal innocence. Whatever I did, but the law, the way it's described, doesn't capture that conduct.
Yeah.
And then there is not proven, which is what we require of the government. We say the government's burden is to prove guilt beyond reasonable doubt. It hasn't taken that on. So I want to ask you about all of these lab cases. If you think about all the drug cases out there, very, very few chemists are ever called into court to testify. Yeah. And the literature is replete with examples. Fred Zane in West Virginia, the Houston Crime Lab. There's reams and reams of evidence to suggest that crime labs either are deeply flawed, or in many instances that analysts are lying about the evidence, or they're tilting the evidence to benefit police officers. And because of deficiencies in the level of defense that it's provided, very, very few lawyers take the steps that are necessary to make sure the chemist comes to court. As a result, there's very little testing of the drug evidence. So let me ask you, would you argue that the person who has untested drug evidence, is that a case that should go to trial? And in particular, let me ask, you got a number of scenarios. The person who thought they were dealing drugs, but it turned out to be laundry detergent. The person who thought they were dealing drugs, but it was a different drug. Or how about the person where they can go to trial, but to get anyone to test the drugs and come and testify will take a couple of years.
Right.
Are those cases that should go to trial?
That's a great question. And I think, here's my answer, which is, I hope, an answer, not a non-answer, which is I agree with kind of the premise behind Abby Smith's argument, the guilty project argument, which is sort of tongue in cheek, which is by focusing on the actually innocent, like the pure, are we creating categories of injustice, like a hierarchy of injustice where the factual innocent are at the top, right? And the guilty masses are down below. And by creating this dichotomy, are we basically selling out most criminal defendants who are not factually innocent, but might be legally innocent or might have been justified or excused in their behavior? They have a colorable defense. Okay, so I acknowledge that. and I've written an article called Innocentrism about the centrality of innocence in our discourse, and kind of defended it by saying, well, just because you acknowledge that one type of error, in your view, or at least in my view, may be a worse injustice than other types of error, that doesn't mean that those other errors aren't also meritorious and should be addressed, right? Just because you say that you like chocolate chip cookies the most doesn't mean you dislike Snickerdoodle. You still might like Snickerdoodle, like they're great cookies, but you just happen to like chocolate chip cookies the best. So I disagree with the idea that, like, if you're fighting for the innocent, it means you're selling out the guilty. It's just a slightly different battle. Do I understand the criticism, which is it takes air out of the room to focus on the innocent, and maybe some of that air is oxygen that the guilty could use to breathe, okay? But then related to your point, Pam, I think that those are cases that should go to trial. I think any case where there is a legal or a factual issue about guilt, that is something that should be contested in open court. It should be subject to the greatest legal engine ever devised for the discovery of the truth, John Henry Wigmore, cross-examination. So if there is an issue of a bad crime lab, there is an issue about whether you sold talcum powder instead of heroin, that should be vetted in open court. And we have to create better incentives for things to go to court. Because right now, as you well know, the incentives for everyone, including defense lawyers, are to get plea deals, right? Just to move along. I mean, how often would you say, you mentioned that a plea deal is good enough, an innocent person should accept it. I mean, that was considered a win. I mean, I know at legal aid, that's a win. Getting a good plea for your client, that's a victory, because an acquittal was something that might happen just once in a blue moon. So that's a long way of saying I think that those cases should go to trial, though there are risks, of course.
There are enormous risks.
When that scientist shows up,
And there are enormous risks in taking a gamble. I mean, as I'm listening to you talk, I'm reminded of when I was a very, very young lawyer, brand new, and I had a client who swore up and down he was accused of couriering drugs into the United States through the JFK airport. And he swore up and down that the DEA in Cyprus had told him he could do this. And since he was coming from Beirut, this was not a terribly persuasive story. And parenthetically, for my law students, I have permission to tell this story. And up and down he swore this. And of course, I'd been a lawyer for about 60 seconds. And nice young man. And he had this insane story. And because I was a baby lawyer, I stayed up in the middle of the night to call the DEA in Cyprus just so that I could lay my head down at night and say, yeah, the DEA in Cyprus says they've never heard of you. Well, lo and behold, the DEA in Cyprus says, oh yeah, we remember that guy. He said he was being threatened by this person, that person, and they told him he had to pay off the debts. And if he couldn't pay off the debts, he had to carry drugs, or they were going to kill his grandmother. And we told him, we can't help you. If they're going to force you, you just got to do what you got to think you got to do to save your life.
Wow.
Yeah.
That's duress.
Yes. But here's what's interesting about this question of going to trial. He insisted he was innocent, very much wanted to go. And the day before I made that phone call, I had this is a deal so good an innocent person should take it, because he was looking at a very substantial amount of time, had been offered, it's something in the 3 to 4 year range.
Wow.
And we brought out the big guns. We used to refer to it as beating someone into a guilty plea, but I was 100% convinced he was not telling me the truth. It was the most ludicrous story I had ever heard in my life. Why was he calling the DEA in Cyprus? Because there was no American consulate in Lebanon at the time. I mean, it was this crazy story. Another year of practice, and I would never have made that phone call.
Yeah, because you're beaten down, right?
I wouldn't have believed it. In a year, I'd heard so many unbelievably outlandish stories that I had a fairly strong sense of which ones were true and not true. And I think I would have assumed this one was not true.
Yeah.
And the reason I mention this story is because this notion of things where there is a doubt or a credible factual or legal argument should go to trial. I sometimes feel like that's a lawyer's luxury and not a defendant's luxury.
Yeah, because they pay the price for it. I realize that.
And it stays, well, not just that, but it stays, how do I say this? There is this sense in which, as lawyers, nobody becomes a prosecutor or a public defender to plead cases. You become one to try cases. That's the sexy thing. That's the fun thing. And you learn very quickly that if you want to do the best you can for your client, you have to readjust like that. But the more that things go to trial in the system we have, as it is resourced, the fewer resources you have to put into every one of those trials, the less diligence you're able to give to each case, the less investigation. If you look at the caseloads that people carry, if you carry 600 or 1,200 misdemeanors, and there may be lawyers watching now who do that. That's, I think, the current caseload for misdemeanor lawyers in Dallas County and the public defender's office is somewhere between 1,000 and 1,200 cases in a year.
Wow, that's amazing.
Who's going to trial?
Yeah.
Which takes me back to the question I keep wanting to go back to with you, which is really unfair, but you said it. You'll take procedure over substance any day. I'm going to make you king. What is the single procedural thing you would do to deal with this, not just for the rapes and robberies and murders, but for everything from pickpocketing all the way up? Is there one thing that you think would make the most difference?
That's a really good question. I mean, it's a little outside my expertise because I focus on the appellate and post-conviction process. But in terms of pre-trial, I actually think automatic early discovery could make the most difference, right? Not delayed discovery, not you mentioned the Ruiz case, that you don't get your Brady material until the eve of trial. You can plead guilty without receiving Brady. And if 95% of cases plead out, that means people are pleading out without knowing the evidence in their favor. I think open file early discovery of all the potential procedural changes could make the most difference. Because one of the problems, and I think, I'm curious what you think about this. Scholars often talk about plea bargain under a market theory, that people are negotiating under the shadow of trial, and they're able to gauge, how much sunlight is left, what their chances are of success. But that's absurd. Defendants are pleading blind. They can't see the shadow. They can't see the sunlight. They are just guessing about the strength of the case against them. In dozens of states, I can't remember the exact number, prosecutors aren't even required to turn over their witness lists. I mean, you don't even know who's going to testify against you, let alone what all the police reports are. So, I mean, I'm curious what you think about this, Pam, but I think discovery could go a long way to helping this. Because then if you saw, it's one thing for you to believe your client and this story about Cyprus. But let's say there is a report from the DEA in Cyprus that validates it, or a report that undercuts it completely. That would affect how you sell the potential plea to your client, I think, in a way that could be really helpful. I don't know. What do you think? I mean, maybe discovery is, again, that's like an appellate lawyer's fantasy and not a trial lawyer's reality.
No, I think you're onto something there. The only thing I'd say is for the discovery to mean something, someone's got to be able to use it.
Yeah.
So I want to flag two things. One, again, if you got 1,200 cases in a year,
I know
you're not looking at much discovery. And I don't know if Andy Davis is doing some research in our office right now about, Texas has something called the Michael Morton Act.
Yes.
Which requires, discovery, open file, and early and often.
Yeah,
so,
that's great.
In many places in Texas, the minute the case comes in and the prosecutors decide they're going to move forward, evidence gets uploaded online. How long it takes somebody to read it, different question. And I will tell you again, every solution has its own problems. Body cams and dashboard cams have become a real challenge for lawyers because the footage is so voluminous that it's hard to know where to start and look. But I agree, discovery early and often is great, assuming you have a lawyer who has the time and the availability to look at it. But I like that as an approach. I'm curious as well, again, going back to this issue about innocence. You toward the end of the book, you make suggestions about where you think we could go. You talk about conviction integrity units. The first one was actually in Dallas County.
That's right. Craig Watkins.
That's
wasn't
right.
it? Yeah.
That's right.
And Mike Ware. Great group.
Yep.
Terry Moore.
And I think Patricia, someone on the chat, I hope, will remind me of her last name. Actually was the first lawyer to work in it. And it's a wonderful innovation, but can't sustain a high volume of cases.
Right.
But I think a very important learning moment for prosecutors. You talk in the book about the role of prosecutors, particularly at a moment when we're seeing I think some very challenging conversations emerging politically about progressive prosecution.
Yes, yes, it's a
What
good
is
way
your
of
thought?
phrasing it.
What is your thought about the role of prosecutors with respect to discovery, but in other ways too, prosecutors as guardians of innocence?
That's a really important issue. I mean, I very much believe in the 19th century maxim that prosecutors are ministers of justice, that they never lose a case as long as the outcome is fair. A victory isn't a conviction. A victory could be an acquittal. If in fact the evidence is more than probable cause, but not proof beyond a reasonable doubt, that should be a win for prosecutors. And declining to prosecute a case where the arrest is specious or you don't think you're going to win at trial, that should also be a victory. The way I would sort of translate that into the post-conviction arena is very much through the progressive prosecution lens. So I'm a big advocate of this. I'm a big advocate here in Boston of Rachel Rollins, who's our U.S. attorney in Massachusetts, was the Suffolk County, Boston, that's the county that covers Boston, Boston's district attorney, who among other things had a very vibrant and vigorous conviction integrity unit, had a do not prosecute list of 15 cases where her office was pretty robust in not prosecuting them. But the blowback was enormous. And that's what we're seeing. We saw it in San Francisco with Chesa Boudin. We're seeing it in Los Angeles. We're seeing it in St. Louis with Kim Gardner. There's a question, I believe, in the progressive prosecution movement, this idea that right now we are overcharging, over-criminalizing, over-incarcerating. And if we, in fact, were a little bit smarter about our charging and prosecuting practices, it would save money, and that we could use that money for other things. For instance, by going to trial in cases that deserve to go to trial, instead of just setting up a system where everyone's incentives are aligned with pleading out. But just to take Rachel Rollins as an example, before she even took office, an organization called the National Police Association filed an ethics complaint, a state ethics complaint against her for reckless disregard of state law. She wasn't even the prosecutor yet. Like, she didn't work as a prosecutor. She wasn't an assistant DA, and she already had an ethics complaint filed against her. Things like that seem to be happening with each and every progressive prosecutor. So I think the political risks are really significant. I don't know if your question was about the political risk as much, Pam, as sort of whether there's like an empty suit factor in some of this, or whether some of the policies aren't as effective as they claim to be. I'm not sure what you're
and
thinking.
You talk a little bit about cognitive dissonance, right?
Yes.
And the way in which, nobody gets, well, I shouldn't say that. Almost nobody gets up in the morning and says, today I'm going to work to convict innocent people.
Right. I think that's right.
I think that's true for police. I think it's true for prosecutors. I think that there is a way in which we all have to believe we're doing good work to want to get up and do it every day.
Exactly.
And that it becomes very difficult, therefore, to untangle your belief in the worth of what you're doing.
Yeah.
In a way that creates healthy skepticism about the cases you're reviewing.
Exactly.
There's a piece of me that has always wondered, and we have a couple of folks in the audience who are vets from the military, although I don't know whether they've been military lawyers, but it's a piece of me that's always wondered whether the military model, where lawyers first draw for the defense and then for the prosecution, builds a better prosecutor and a better defender. But particularly on the prosecutor side, I wonder if it builds a better prosecutor, because I wonder whether it turns on a skepticism muscle.
Yes.
So going back to your point about Brady, I know prosecutors who have said to me, when I've brought them in to teach professional responsibility, and I talked to them, they do my class with me on Brady, and I had a couple of instances where a prosecutor said to me, oh no, I wouldn't have disclosed that piece of evidence, it wasn't exculpatory. And I had to say, well, but what if the defense theory was XYZ?
Right. And you don't know.
And a case with, for example, the questions whether the sperm are motile. And the prosecutor says, well, how could that possibly be relevant when this person says it was a consent case? The answer is, well, maybe we would change our defense, or maybe there's another story. And I don't think that's because they want to be unethical. It's because they cannot possibly do the work that they've been asked to do, even with open file discovery, knowing what questions to ask the police, being creative about what should be in the file. it's a Herculean task, I have to imagine. I mean, I've never prosecuted, but I have
Yeah.
to imagine the burden is overwhelming, and the mental contortions that it
Yes.
requires have got to be almost insurmountable.
Well, two thoughts on that, because I think you're exactly right. The first is I think the mental contortions are almost insurmountable. And some people, including Alifair Burke, has written about this, that basically these dual roles for prosecutors, they're supposed to be ministers of justice, concerned about all of us. They represent the people of the jurisdiction, not the victim. But then on the other hand, they're supposed to be zealous advocates for the government position, and strike hard blows, but not foul blows. That those obligations are in disharmony. And they're really, to some extent, at loggerheads, and it's very hard for you to reconcile the two, which means you usually just pick one of them. And that means you tend to pick the advocacy role, because that's how you advance in your office, right? You win cases, you get successful convictions at trial, you produce very favorable plea bargains from your own perspective. And that's why I think the second point, your suggestion about having criminal lawyers, not criminal defense lawyers and prosecutors, and where you can just take cases, right? Be assigned different cases by a judge, perhaps, or have stints on both sides, would be a really good model. And in fact, I've heard that this is what happened in the UK up until 1986 or something like that, that there was just a criminal bar. And you could serve as a prosecutor, you could serve as a defense lawyer. And then only when the caseload was so enormous did they have to create an institutional prosecutorial office. But some people I've heard have argued that that's one reason why sort of the culture is slightly more hospitable. I don't know if this is true or not, to the idea of error and to the idea of an unsafe verdict. In the UK, they have this concept of an unsafe verdict, and they have a very large nationwide innocence commission called the Criminal Cases Review Commission that looks at these cases and refers unsafe verdicts to the Court of Appeal for review. I think that's a really healthy and thoughtful suggestion. Let's have criminal lawyers, not defense lawyers and prosecutors. The problem, of course, is the volume of cases. It goes back to your fundamental point, Pam, which is, if the average public defender in Dallas County has 1,000 to 1,200 misdemeanors, you're going to have 600 misdemeanors as a defense lawyer and 600 misdemeanors as a prosecutor? Like how do we make this happen? So in many ways, it really just comes back to dollars and cents. We need better funding. We need to pay more attention to criminal justice, I think. And then we could maybe save money through on the back end by not incarcerating so many folks.
Or by making a smaller system overall, but I'll put a pin in that. So
yes.
I want to flag that you talk in the last chapter of your book about commissions and how they may be a better model for handling innocence cases. You talk about the Criminal Cases Review Commission in England, the UK, which, if I remember right, they do. I think the total review was somewhere around 28,000 cases.
That's right.
A period that was more than 13, 14 years. That's a drop in the bucket still. But I would think that at that rate, you might develop some skepticism. Is there any evidence that the review itself is creating that kind of skepticism in practitioners and judges?
Oh, that's interesting. So the idea that so few cases are being referred to the Court of Appeal as a result of this review process that it might create the impression that these cases are scarce. Was that your suggestion?
Conversely, that it might create the impression that it's all taken care of now.
Exactly. So that's the risk, right? Mm-hmm. That's a risk that I think those of us in the so-called innocence movement, we've branded this. I don't know if it's trademarked or anything, but in the innocence movement, right, it's a fear, which is every time there's a newspaper article about an exoneration, every time the North Carolina Innocence Commission plays a role in exonerating someone, is there a perception that the system works, right? And that we catch all of these errors? Maybe it's justice delayed, but it's justice achieved. And from, I think, the message that we are trying to promote, many of us who do this work, is, again, this tip of the iceberg argument, which is, yes, these cases are so hard to overturn that the ones you hear about that make it through this process are just the exception rather than the rule. And we have to change the system to avoid these types of mistakes. So I think that is a little bit of a risk, right? That if you have a commission and they review 2,700 cases, I think that, or 27,000 cases, I think in the UK, of those 27,000 cases they reviewed, something like 580 or so were reversed. I'm not sure if I have my math correct, but the exoneration rate was 2.8% over this period of time, like a 20-year period of time, which is a pretty paltry number. Right? That's a pretty paltry figure. 2.8% of the cases where someone sought an investigation and claimed to be innocent, that's a pretty, specific a subset of the criminal population or the incarcerated population. So I agree with you. I think that's a risk. But then my response to that is, isn't it still better to free those 2.8%, those 577 people who otherwise might still be behind bars? So, right, I don't know. Or do we change the system entirely to avoid, obviously the better thing would be to change the system entirely to avoid these front end miscarriages of justice.
Or both.
Or both,
I'm noticing we're starting to get some questions in the Q&A. Folks,
Yay.
Please go ahead and put your questions in there. I want to ask Daniel just a couple more questions about the book, and then we're going to open it up for group questions. Elsewhere in the book, you talk about why it is that parole and clemency are inadequate to these tasks. And I want to focus in on that for just a minute, because I think what might be on some people's minds with the recent announcement of the Biden pardons for marijuana possession cases, somewhere around maybe 6,000 people, if we can find them, round them up and get them through the process. Can you talk for a minute about what your concerns are with using executive relief, whether through clemency or pardon and parole?
Yes, so it basically comes down to this. There's a lot of diffusion of responsibility in the criminal justice system. So in a lot of these appellate and post-conviction cases, right, you will see judges saying, well, innocence is not something that we will recognize in federal habeas corpus, let's say. And for people claiming to be innocent after trial, the best remedy is executive clemency. Right. So you see a lot of judges pointing to executive clemency, pardons, commutations as the way for the actually innocent person to have a chance at justice. The problem with that, though, and this is where the diffusion of responsibility comes in, pardon boards, parole boards, they will then point back to the courts and they'll say, our job isn't to relitigate guilt or innocence. We don't do that. We evaluate the candidate for mercy. We try to determine whether they deserve forgiveness. And a threshold step in obtaining forgiveness is admitting that you did something wrong. How can we forgive you for doing something wrong if you claim to be innocent? You haven't come to terms with what you've done. You don't deserve mercy. So both parole and the pardon function, they have these really odd origin stories where they're grounded in this idea of admission of guilt, acceptance of responsibility as a prerequisite to getting relief. Clemency, I've heard, derives from ancient Rome and the goddess Clementia, and it first came into prominence when Julius Caesar would grant clemency to fallen soldiers who had just fought against him. And the idea was he was exhibiting mercy. He was displaying magnanimity to all these enemies. But there was no question of them being innocent. They were enemies. They had fought against him. They had wanted to kill the Romans, but he was going to give them clemency. Parole emerged much later in the 19th century, and it was based on this whole concept of a parole honneur, this idea of from France about honorable prisoners who had been rehabilitated and deserved forgiveness, who deserved grace. So everything about those remedies, sort of from age-old days till now, is about something other than actual innocence. But yet courts seem to think, well, executive clemency is the fail-safe. In fact, Justice Rehnquist said that in the famous 1993 Herrera decision, in which the Supreme Court said that actual innocence is not in and of itself something that should be recognized for federal habeas relief. So that sort of is in a nutshell why I don't think these executive remedies work. The commissioners just aren't looking for innocence. They're looking for redemption. They're looking for rehabilitation. You have a better shot at getting a pardon if you committed a heinous murder while you were really young and grew up under arduous circumstances and have done a really good job in prison avoiding disciplinary tickets. Well, guess what? Innocent people often don't fare well in prison because they're angry and they often have really extensive disciplinary records. And then when they face the parole board or they seek a pardon and they claim to be innocent, then the board is very skeptical and it's going to say no.
So let me turn to one last topic before we open it up to the group. What about the problem of thinking about innocence in a world in which some people are simply perceived as guilty simply by the color of their skin or their citizenship? Bennett Capers, who I'm sure you know, has said, when you talk about criminal justice, race is not the elephant in the room, it's the room, right?
Yes.
Race is the elephant. And so much of what the thread that runs through many, many, many of these innocence cases, not all of them, but many of them, what runs through them are narratives about race. And in fact, it's fascinating to me watching what's happening right now in politics as we're swinging back towards the tough on crime narrative.
Yes,
it's
it's
just
amazing.
a very interesting piece in the paper about the way race is being used in political advertisements, including even darkening a white person's hands to suggest that they might be a predator. I can't remember the narrative. But
oh my gosh.
We live in a country in which the criminal legal system was in many ways built to reinforce white supremacy, to reinforce social and class hierarchies, and in which innocence as a presumption, right? There's supposed to be a presumption of innocence. Innocence is not presumed.
Right.
Police don't presume people's innocence. That's not even their job. Frequently, our own implicit biases and sometimes our explicit biases mean that we don't perceive all people as being equally innocent when they're simply walking down the street.
That's right.
What does the problem of race in innocence mean when you think about it as a piece of the innocence puzzle?
That's a really, really important observation. And I think I agree with what's animating your comment and question and what Bennett said, which is race isn't the elephant in the room, it is the room. You really can't talk about any aspect of criminal justice without highlighting the pernicious effect of racism, both historical, the legacy, but current as well. So in innocence, the innocence issues, here's what we know. There's data that suggests that people of color, especially Black men, are about 7 times more likely, if they're innocent, to be wrongfully convicted than white people, statistically. That essentially all of the racially discriminatory effects of other aspects of our criminal justice system also appear in the data set of wrongful convictions. There's also reason to think, and we haven't been able to quantify this, that people of color are less likely to get access to innocence projects and the ears of conviction integrity units and various other institutions that could help lead to exoneration than white people. Just that many of the same barriers that can lead to maintaining the marginalization of vulnerable people of color, are perpetuated throughout the post-conviction, appellate, and sort of non-profit innocence project experience as well. Though we haven't been able to quantify that because we can't quite figure out, we know who has access to an innocence project, who has written an innocence project, but we don't know who hasn't, right? We don't know what that sort of a denominator might be. But we also know that, for instance, cross-racial misidentification, especially where a white crime victim misidentifies a person of color as the perpetrator, is a huge factor in many of these cases. Something like 70% of documented exonerations involve some type of mistaken ID, and the majority of them fall into that sort of subcategory across racial misidentification. So this is something that people doing this work are really well aware of. As I said, it's hard to talk about any aspect of this without talking about race, because it pervades everything.
Can I ask, do you know, are the percentage of white people who are exonerated through innocence commissions, is it disproportionately high compared to their compared to their presence in the overall jail population? In other words, I'm wondering,
yeah, that is so
whether they get the
interesting.
extra benefit of whiteness in the innocence process as well.
That's interesting. I don't know. I actually don't know. I haven't seen that data. I'm sure we could do that, right? We can, yeah, I'm sure we could figure that out. I think for somewhat obvious reasons, most of the advocacy arguments are about the racially discriminatory impact on people of color, in this data set amongst the wrongfully convicted. But that would be a really helpful argument if, in fact, the data support that, to show that, look, white people are getting out of prison at a higher rate than they are as a percentage of the carceral population, which suggests that they do have the benefit of whiteness throughout the process. I mean, there's reason to think that's the case, right? And there have been a number of high-profile exonerations involving upper middle-class white people who had access, to the levers of power.
And there's a great PBS video called The Plea. And one of the things my students watch this every year when I teach adjudication. And it's interesting to me because there are a couple of very high profile innocence cases, but 3 of the 4 cases that are profiled are of white people.
Interesting.
Which I find fascinating. Let me switch tacks because we do have some questions in the chat, and then I want to give you a chance to wrap up. Someone asked, if discovery is handed over early and often, what can be done to guarantee that the defense lawyer will review it prior to a plea bargain or trial? And the particular question is, in some places, prosecutors have to certify that they've provided discovery. Would you advocate making defense lawyers certify that they performed a sufficient investigation? Would that be a useful strategy?
Yeah, I think that's really interesting. I think that's a super interesting suggestion. I think that's not a bad idea. That's my instinct. And sort of here's why. Regardless of what, they're going to sign it no matter what, regardless of whether they do it or not. But I've been influenced by, and I don't know if you've read this, Pam, the Checklist Manifesto, that book about how checklists can improve favorable outcomes, right? So a big story in that book was about how there were a lot of deaths in a particular hospital in the Bronx simply because nurses and doctors weren't washing their hands before treating a patient. They just forgot to because they were rushing into the room. So the hospital instituted a checklist outside the door where you had to sign that you had washed your hands before coming inside. And the rate of infections dropped precipitously just as a result of that checklist. So I think this suggestion here, this thought here, is a little bit similar, right? If the defense attorney has to assert that they have reviewed the material, maybe they haven't in some instances, but it will sort of make you think, oh, I should probably review it. And if you're thinking you should probably review it, then you might do it. And that could probably improve your performance, though it doesn't go to that fundamental problem you identified, Pam, which is, what do you do with the other 999 cases or 1,199 cases on your docket?
So, I'll also flag, by the way, that it's not always in the defendant's best interest. If somebody walks in and says, I'll give your client a plea to time served today and they can go home, and you say, well, I'd really like to review the discovery first. That's a tricky question about client autonomy. But let me put a pin in that and say, yes, I'm a very big fan of the Checklist Manifesto. Several years ago, Andy Ferguson and I wrote an article called, Andrew's great, and called Defending Data. And
that's a great article. I forgot.
You did that. And our initial premise was we were going to write the ineffective assistance of counsel version of the checklist. Yes. And we ultimately abandoned the checklist approach in part because we believed that it would encourage a kind of check the box approach, and in part because we believed that it was going to further insulate lawyers from ineffective assistance of counsel.
That's the downside.
We were that what we were building in was essentially an even greater hurdle for defendants to overcome in arguing that they had received ineffective assistance. The other piece of it, I think that we struggled with somewhat is what I just alluded to, that this is a really messy, tricky business. And the reality is that all the conversations we're having right now about what lawyers and judges can do ignore the problem of autonomy for defendants. And the reality is that there are important conversations to be had about people's rights to about the right somebody has to make a terrible decision.
Yes.
You may remember, you may even have been involved in this, a case out of New York State that made its way through the federal habeas process up to the Second Circuit called Boria versus Keene. And
I don't know.
it's a New York State case under the old Rockefeller laws, where the lawyer looked at the discovery, and it was before Lafleur and Frye, before the Supreme Court had said you had a right to the effective assistance of counsel in plea bargaining. And the defendant was looking at a lot of time. The lawyer had reviewed the discovery and came in and told the defendant, you really ought to take this deal. It's a good deal. And the defendant said, I just can't. I can't get up in front of my kid and plead guilty.
Yeah.
I cannot do that. I just can't do it. And now the lawyer did something very different than what I would have done. The lawyer said, well, that's a rational choice. Okay, let's go to trial. My own view is that's probably a poor exercise in lawyering. You've got some obligation to put the screws on a little bit, say, let's talk about what your child might want to see their dad in a couple of years or to wait 20.
Exactly.
But clients do have the right to make bad decisions.
Exactly.
And the other piece about a checklist is I don't think it takes account of the fact that ultimately the person in the driver's seat is the defendant. And if the defendant says, I don't want you talking to my mother, then I can't say I've talked to all the witnesses. If the defendant says, I don't want you going to, I don't want you looking at the discovery. I want to take a guilty plea today, and it's going to take you 2 weeks to look at all the wiretaps.
Yeah.
What's your obligation? I think you can make a record. Judge, my client instructed me not to look at the evidence, and the judge is going to say, oh, okay, well, one, that's an attorney-client communication, so there's a problem, and two, fine, we'll just wait, and then you've defeated your client's autonomy. And I know the students out there are probably going, well, okay, well, once again, you've talked yourself into a dismal note helps. I don't think that's true, but I think that there is a problem of unintended consequences in everything we do, which is why my position over the years has sort of hardened into the best solution is less. It's fewer crimes, it's less prosecution, in part because these issues are so complicated and they take up so much of our public fisc, but in part because when we crowd the system, and Alexander Napatov has written so eloquently about this, but when we crowd the system with nonsense, and here I'm going to put in, low-level cases and, the public urination and drunken disorderly and all those cases, when we crowd the system with that, what we do is we put lawyers and judges, both on both sides, prosecutors and defenders, in the position of becoming case processors.
That's right.
Rather than thoughtful lawyers. And there's no room to say, what would a real checklist do? There's no room to say, what would an innocence commission do?
Right.
What could we do with discovery? Because the volume is so high that it's conveyor belt justice.
Yeah,
and
I think that's right.
I don't know how the narrative of innocence, what you said earlier, it takes up all the air, and it does sometimes.
Yes.
Right? It's very hard to represent people in cases where they've had unjust results and everyone wants to know but are they innocent?
Yeah, exactly. That's a horrible thing.
It doesn't matter. The police violated the Constitution, right? But are they innocent?
Right.
Okay. But the truth is that one thing that the innocence movement has done so powerfully has been to impress upon our national psyche the humanity of people.
Yes, I think that's
in this criminal legal system, to create moments to recognize their humanity. So in the last few minutes we have left, I want to ask you, because the folks on this call are here because they're interested in these stories of humanity, because you wrote a book that tells stories and connects them to legal doctrine. If you're not a law professor or an appellate lawyer, or you're early in your career, or maybe you're just a regular person who hasn't had the insane misfortune or fortune, depending on how you view it, of going to law school.
Yeah.
What's the call to action here? What can people do to take steps to address the crisis of innocence, the crisis of procedural injustice and the way it contributes to substantive injustice? What's the call to action here?
This is going to be a somewhat unusual response, but I think it's actually the most important thing. Empathy. It really comes down to empathy. And in many ways, that's the end note of this book. So I started with the story of Stephen Schultz when we began this, and I talked about how he got out. Well, here's what's happened to him since he got out. He became a long haul truck driver, and he called me from Maine when he had tasted lobster for the first time. And that was one of the highlights of my professional career, right? Like, yeah, he only got out a few months early. He would have gotten out for good time served if the habeas hadn't released him. But, he was tasting lobster. And then I reconnected with him recently. He's living in New Jersey with his longtime partner, Lisa, and their dog, Christmas, a stray they found on December 25th a few years ago. And then I asked Stephen, I just was thinking about this and we were just, jabbing away. I said, Stephen, what's the thing you appreciate the most about your freedom? You've now been out like over 10 years. What is it? I thought he'd say something like Christmas, my dog, or, Lisa holding hands on the beach or whatever. And he said, my debit card. I'm like, what? He said, yeah, my debit card, because I use it like every 30 minutes or so to give me an alibi. So I will always be able to prove where I was at a particular time in case the police come around to tag me for a crime I didn't commit. And it was the most, memorable exchange I'd had with him in years. This idea that 10 years, 12 years, 14 years removed from his freedom, the debit card is what he prizes the most. I mean, he is a real person who is dealing with post-traumatic stress disorder. He is just one among many. And then the last thing I'll leave people with when it comes to empathy is I had an exoneree come to my class the other day, a guy named Jabir Pope, who'd spent 38 years in prison. And I had him come with his lawyer, a guy named Jeff, who was a graduate of our law school, Northeastern. That was the hook to have them come in. And he turned to Jeff and then he turned to my class and he said, you know what the difference is between a lawyer and an attorney? We all thought it was like a trick question. Like, what was he going to say? He said, well, I had lots of lawyers and they knew how to apply the law. But Jeff was the first attorney I ever had because he listened to me, right? He listened to me. He treated me like a person. He believed that what I said had value. And Pam, this comes full circle to your investigation of the DEA Cypress story, right? Like you didn't necessarily believe it, but you followed up. And that's what we should all try to do to the extent we have the bandwidth to do it, to display empathy, to feel empathy, and to sort of give our clients the benefit of the doubt, to give people who aren't necessarily like us the benefit of the doubt. That's sort of my parting, I don't know, not a word of wisdom, but a call to action.
Well, thank you for that. I mean, it was a terrific book. I really enjoyed it. And I say that,
Thank you.
look, I don't generally like reading the legal stuff. Often it's a
Yeah.
busman's holiday. And I find
Right.
myself saying, oh, but for those of you who haven't had a chance to read it, it's such a lovely, clear exposition of what the problems are. It's such an accessible and compelling story that weaves in legal issues. I also want to just put a brief plug in here for an event we're having on November, I think 3rd. Kanitra's going to put it in the chat. But on this topic of empathy and wondering about Cypress, there's some scholars out of both, I think out of New Mexico, but there's a study that was just done on search warrants and what judges do with search warrants. I think as lawyers, as defense lawyers, at least, we all suspect that judges just, kind of sign off on them, but we could never really prove it. This is a new study that looks at search warrants and search warrant applications from Utah, all of them from 2013 to 2021. And what we learn is that 98% of search warrants are approved, 90% of them on the first look, and most of them within an average of 3 minutes.
Oh my gosh.
And I say that because, first of all, it should be a very exciting talk. It's part of our Works in Progress series, and I hope folks will try and join us and attend. But what's interesting about it is this moment you said of empathy, to stop and think about it. The machine of processing all this paperwork. If we all just stopped for a moment and asked, is there another side?
Yeah.
Is there kind of a different story? Is there a different narrative that we can tell ourselves? Is there a different way to see this? And I guess I want to read a little bit of what you say at the very end of your book. You talked at the very beginning of the book about this idea that your first-year law professor said, which I guess I've agreed with: procedure trumps substance every day.
No.
And you kind of imagine a different world. And what you say is prisoners with viable innocence claims deserve painstaking, transparent evaluations by neutral decision makers. They deserve a system that values accuracy over finality, efficiency, and deference. They deserve to live in a country where, with all due respect to my first-year law professor, substance wins over procedure. And this is a book that makes a powerful claim that that's the way the world should be. And I encourage folks to pick it up if you haven't already. And Daniel, thank you so much for joining.
Thank you so much, Pam. I had a wonderful time, and I'm so impressed with you and the center's work, and consider me a longtime ally and fan.